This is my presentation on the Fourth Amendment and search and seizure rights. So there are three pillars of the criminal justice system, and they're very crucial to the system as a whole. You have law enforcement or policing, you have the judicial system, and you have corrections. So these three things are the backbone of the safety in our nation. Each pillar is said to be interconnected, playing a crucial role to infer legal proceedings and community protection. So as for law enforcement, under the policing pillar of criminal justice, the Fourth Amendment is very crucial. According to Indiana Wesleyan University, these are some of the qualities of the policing pillar. So police officers are the first line of defense against crime. They're first responders, they're usually the first ones at the scene of a crime. They are at the local, state, and federal level, and they prevent and investigate crime. They are there to enforce the law. They maintain public order, and they are here to apprehend and arrest offenders. In the apprehension of offenders, officers have a list of rules to follow which lay in the Constitution of the United States of America. So they have rules, and they have to abide by the constitutional rights of the people, but they do have discretion. Police officers do have discretion, meaning they can make decisions based on personal judgment instead of formal rules. But the thing about discretion is it has to be absolute. It has to be justifiable. It has to be absolute. So the Bill of Rights covers all three pillars of criminal justice as they guarantee personal freedoms and limit government power. It derives from the Magna Carta, and it gradually broadened the concept of equality among the American people. Within the Bill of Rights is the Fourth Amendment, which officers must have an understanding of to do their job. They have to have an understanding of the Fourth Amendment. So the Fourth Amendment was established in 1791. It forbids unreasonable search and seizure of individuals and of property. It was originally introduced in 1789, where it was stated that every man's house is his castle. And the balance between the rights of the persons and law enforcement officials has undergone much debate. Um, so the amendment contains two legal concepts that are crucial: a prohibition against unreasonable searches and seizures, and the requirement of probable cause. So to be able to search and to be able to seize, you must have probable cause. There's no if and or but, you must have probable cause. So these things are why a search warrant must be obtained. So, a search warrant is a legal document signed by a judge or a magistrate. It describes the place, the person, or the thing that is to be searched or seized. This is what makes search and seizure reasonable. This is what gives officers permission to go onto a property or search a person, and probable cause must be proven to get the warrant. An issue, however, with search warrants, according to a study that was conducted in 2025 by the Harvard Law Review, is that warrant review is found in Utah, where they have an e-warrant system where you can electronically submit a request for a warrant. It is generally high approval, fast, and procedurally light. So in Utah, 33,000 applications were filed. 98% of these applications were approved, and over 90% were approved on first submission. 1 in 10 warrants were opened, reviewed, and approved in 60 seconds or less. This means that the judges or the magistrates or whoever was in charge of approving these warrants did not read them carefully or read them in full, meaning they didn't know if probable cause was justifiably established, if probable cause truly was there. So, for a search and seizure to be ruled unlawful means three things must have occurred, according to Cornell. The lack of a legal search warrant, um, the search took place without probable cause, or the search and seizure was extended throughout the authorized scope or the authorized period of time they were given to search the premises or search the person. And as mentioned previously, some argue that search warrants approved may even be unreasonable, as judges may rush and give automatic approval, meaning they may give too much time that was asked for. I mean, they could have asked for a certain amount of time in the request and they could have given it to him and it wasn't that much time needed. Or probable cause may never have been established. So, in the case of Collins versus Virginia, this is probably the most famous case regarding the Fourth Amendment, where there were a series of traffic incidents involving a black and orange motorcycle in Virginia. Officer Rhodes discovered photographs of an orange and black motorcycle on Ryan Collins's Facebook page, and that was the grounds that he had to go to the premises where he went to the property. He parked his car outside. He went to Collins's property, and there was a tarp where he assumed the motorcycle was. He lifted the tarp to see that there was the orange and black motorcycle. So he lifted the tarp, he ran the plates and the model numbers, and that is how he discovered it was stolen. To where he waited outside of the house and waited for Ryan Collins to return, which is where he made his arrest. To where he tried to argue the automobile exemption, meaning there's an exception in the Fourth Amendment where you don't necessarily have to have a warrant for automobile searches. Um, the automobile exception did not permit the entry of the home or its curtilage. The motorcycle was in the driveway of the home, and the Fourth Amendment covers the curtilage around the premises, meaning it's what's immediately attached to the house, which is the front yard, the driveway, things like that. And the Supreme Court had ruled that Rhodes had overstepped the boundaries of his authority. It was also found that his discretion was not absolute. He made a judgment choice to go onto the property, lift the tarp, and search through things to find the motorcycle. And it was found that his discretion was not absolute. The only sort of probable cause is that he saw a picture of a motorcycle that matched the description on Facebook, and that was not enough for probable cause to be had. So, as for the three pillars of criminal justice, the case of Collins versus Virginia demonstrates the three pillars in the Fourth Amendment. So, as for law enforcement, officers were held accountable, and it was demonstrated how they should uphold the law. As for the judicial aspect, the Supreme Court upheld their duty of maintaining the Constitution and the rights of the people. And as for corrections, he was indicted before the Supreme Court ruling, therefore, the ruling was not overturned. So, even though he was unlawfully arrested and it was found that the motorcycle was stolen, he still was punished for stealing a motorcycle. He did not get away with stealing a motorcycle simply because an officer made a poor choice. So he still was punished for his crimes. And these are all of my references.